Hello, everybody, and thank you for joining us again. This is Jennifer from Weinberger Divorce and Family Law Group. In today's webinar, we're going to be talking about the New Jersey Division of Child Protection and Permanency, or DCP&P. This is the organization that was formerly known as DYFS, and perhaps you might have some questions if you have found that DYFS has become involved with your family. And we're lucky to have with us today as my co-host, fellow Weinberger Divorce and Family Law Group attorney, Marquis Jones. He's very well versed in the area of DCP&P and DYFS, and he actually was a Superior Court judge, so he has the experience of not only litigating these cases on behalf of parents, but also hearing them. So we're lucky to have him with us. Thank you, Marquis, for joining us.
Thank you. It's a pleasure.
And we are live, so feel free to ask any questions you might have in the chat box below. If you feel more comfortable, you are free to direct message us and we can answer your questions when we are finished here. As you know, our webinars do stay on our Facebook page, so you're free to come back and view this again as you'd like. So let's get started. Questions and answers about the New Jersey Division of Child Protection and Permanency. Our disclaimer: this presentation contains general information and does not constitute legal advice. Please be sure to direct specific questions about your own situation to an attorney. And talk to us. As I said, we are live as we're going. Give us a thumbs up when you find this information useful. Hopefully you do. Ask us any questions again by leaving us a message below, and we will do our very best to answer them live as we're going on. All right, so let's get started. I'm going to start us off, and then Marquis is going to jump in with any information he feels pertinent, and then he's going to do a little Q&A with me as we move along. So questions and answers about DCP&P. What happens when DCP&P becomes involved with your family? What are we going to cover today? First, we're going to talk about what is the New Jersey Division of Child Protection and Permanency. Then we're going to have our Q&A with Marquis. And then at the end, if we have any questions, we'll be sure to attempt to answer them and also provide you with some additional resources if you need more information once we're done. So part one, what is the Division of Child Protection and Permanency? Well, the Division of Child Protection and Permanency, or DCP&P, was formerly known, as we talked about earlier, the Division of Youth and Family Services, or DYFS. Now, the Division of Child Protection and Permanency is New Jersey's child protection and child welfare agency, and it actually falls within the Department of Children and Families here in New Jersey. DCP&P is responsible for, number one, investigating allegations of abuse or neglect, and also arranging for the child's protection and providing support to the family if either is needed. Now, DCP&P has determined that a child has been harmed or is at risk for harm. The division can ask the family court to place the child in foster care, and the division can provide services to the family such as parenting skills classes, counseling, substance abuse treatment, and mental health services.
You know, I think one of the things here is to, if I may, recognize,
of course,
on a couple levels that the division, and I always refer to it as a division, just in short. But in terms of the dual responsibility that it has, which sometimes presents as an internal conflict, because while it's protecting the safety of the children, it also has a statutorily mandated mission of trying to reunify families and keep families together. But what's important in the context of the second mission is there is such a broad range of services that the division can provide for a family. Like often people do not think of the division as being able to provide things such as housing, but it can. It can provide housing for family, rental assistance for family. It can buy cribs, furniture, things of that nature for family. So their ability to deliver services is really a broad ability.
Marquis, are families made aware of that when the division gets involved, that they can be provided with services such as cribs and housing? Because I didn't know that either. I mean, my expertise, I don't have a lot in this type of work, which is why I'm so happy you're joining us. Are they made aware of that?
Well, no, often they're not, and that's unfortunate because it really depends sometimes on the attorney that they're working with who is aware of this. Because I've had cases, particularly when I sat on the bench, where I've even ordered the division to provide things such as orthodontic services to a family. So, I mean, there is a broad range of services that they can provide, and there are times when I've also ordered, in order to keep a family together, if they're suffering perhaps a temporary situation with housing, that rental assistance in order to get them into some type of safe and secure housing for the family, such that you don't have to end up removing children from the family and keeping them together. And I definitely have ordered things such as housing and rental assistance for families.
Fascinating and really important, and we'll talk about this in a little bit, how important it is to really consider getting involved with an experienced attorney to help you if and when the division comes knocking. So let's get to some of those questions that I actually formulated with Marquis before we joined you today, because quite frankly, some of them are questions that I had, and we wanted to approach this as though we're providing information to parents out there who simply may just not be educated. So Marquis, the first question I wanted to put to you is, what should a parent do first if they're contacted by the division?
Well, again, it always depends on the facts of the matter. And I think what's so difficult in the context of dealing with the division is, one, the reputation that's out there about, the division as far as their intrusiveness into a person's family life would tend to put people off in dealing with them. And it's a very difficult decision that parents often have to make when they're first contacted by the division. But I think what has to be kept in mind is they're not going to go away because they're mandated to investigate any referral of child abuse and neglect. They have to do it. So I think that the question that every parent must ask themselves when they're first contacted about the division, of course, are questions to the extent that your level of cooperation may bring you further into the target range for the division. That's why it is often important that they contact an attorney as soon as possible, because you don't want to be seen as not cooperating with the division, but at the same time, you don't want to put yourself in a situation where you are in fact escalating their involvement in their life in your life. So an attorney is going to be able to sit down, and at times they can act as that buffer and even set up meetings between you and the division, so the division gets an opportunity to have their questions answered, but at the same time, the attorney can make sure that you're protected in the context of the sort of questions that are even being asked of you. You have to keep in mind that sometimes, because this information is far-reaching in terms of what can go on, so you really should contact someone as soon as possible once they do contact you.
And I'm sure it's an emotional support too, Marquis, to have that sort of pressure removed from you if you have an advocate.
Sure. And often if you have someone who can speak, at least for you, because a lot of it is sometimes an issue of just communication. Because look, it's not a comfortable situation when someone's knocking at the door and your first response is, well, are they going to take my children? And you recognize that there is a possibility that could in fact happen. Now, there are times, of course, when they do just remove children and you really don't have an opportunity to respond till you get in court.
All right, let's take the next one, Marquis. Should a parent, and we kind of touched on this a bit already, should a parent consider hiring an attorney if DCP&P or the division becomes involved? And here you got a little bit more specific when we were chatting about this, that yes, if you receive a complaint.
Yes, absolutely. Anytime that you receive a complaint or a summons for you to appear in court, because you have to keep in mind that sometimes you're not going to see the actual complaint until you get into court, depending on what type of complaint the division is actually serving, or if they have removed the child prior to going into court. But I would say definitely anytime you, and you are fortunate if you actually been served with the complaint, but anytime you have the complaint, you should sit down and go over that complaint with an attorney, because there are certain things that are going to be contained in that complaint where an attorney is going to be able to discuss with you the potential outcomes of the matter and things that the division may be looking at that's not readily apparent to you upon your review of the complaint. For example, they might mention something in passing within the context of the complaint that an experienced attorney is going to pick up on and say, hold on, it's not that they're just looking at A, they're really kind of looking at B as well. And you want to know that so that you can present yourself in the best possible light, as well as any proofs that you may have to refute things in the complaint. Often there are things that are in the complaint that are inaccurate as well. So you want to be able to deal with those issues, and an experienced attorney is going to go through that complaint line by line and let you know whether, there should be other things you're concerned about, other things you should be preparing yourself for, whether there's additional information that you really need to get together.
So important to have an eagle eye and experienced and trained eagle eye on these documents. Marquis, how does the division define abuse and neglect? We hear those terms frequently paired with the division and paired with each other, actually.
Correct. Well, and I've gone through this, and I say, if you look at the slide, technically, only the division, only a court can really define it, because it's pursuant to a statute and administrative codes that term technically is defined, because the division, as it operates, can actually operate on two fronts. One is an administrative front where you never ever go into the court, and it can issue a letter as to the conclusion of its findings, and it will use those terms, abuse and neglect, sort of in a loose way, where they say, well, we found that, based on our conclusions, there's evidence to suggest abuse and neglect. And if you really look at the letter closely, they're really not saying that they've defined it or come to that conclusion, as opposed to a court who is actually looking at the actual law in terms of defining abuse and neglect. But the point being, there are so many things that can rise to the level of, and we use the word they're in, but it's really abuse or neglect that they can come in on. But it can range from anything, of course, to a child's death to excessive corporal punishment. So it really is a range of certain things that are done to a child that can rise to that level.
Marquis, I put up here some of the definitions, the injuries that can be defined as abuse or neglect by the court, and you'll see here there could be, as Marquis said, anything from death to, emotional impairment. Some types of injuries that can be defined specifically as abuse, torture, confinement, sexual penetration, tying, all, difficult things to think about when it comes to children, obviously, but Marquis made it a point to define or lay out for us what the New Jersey Administrative Code or the law actually defines as abuse and neglect. So you'll see those here, correct? Marquis, am I speaking correctly here?
Right, and that was just provided as to trying to provide more concrete examples, because if you look at the actual statute in New Jersey and how it defines abuse or neglect, and it starts out in a rather broad sense. So the statute would use the language that, an abused or neglected child means a child less than 18 years of age whose parent or guardian inflicts or allows to be inflicted upon such child physical injury by other than accidental means which causes or creates a substantial risk of death, serious protracted disfigurement, protracted impairment of physical or emotional health, or protracted loss or impairment of function of any bodily organ. Now, that's just one definition of it under the statute. But you ask yourself, what does that mean? And so now under the administrative code, you start to see some of the concrete things that could fall under that statutory definition with regard to that. Another definition of the statute is a child whose physical, mental, or emotional condition has been impaired or in imminent danger of becoming impaired because of the result of the failure of the parent or guardian to exercise a minimum degree of care with regard to supplying the child with adequate food, clothing, shelter, education, medical or surgical care, although they're financially able to do so. So again, that's kind of a broad definition that the administrative code helps to define. I would say, I think an important point that should be raised here is, particularly with regard to the last definition that I read, that's under the statute, is you have to kind of look at, because some things are just incidents of poverty, which cannot be considered abuse or neglect under the statute or under the administrative code. So that's where you really need an attorney to go through, understand the definitions as they're contained in the statute, interpreted through case law, and under the administrative code.
And it also, too, Marquis, reminded me of what you said earlier about the division being able to provide supports that would remediate some of these specific instances that you provided to us here, such as, housing if there's inadequate shelter or inadequate medical care, the orthodontics that you mentioned.
Correct.
All right, let's move on to the next question for Marquis. My child was removed from the house. What can I do? Marquis?
Well, this is definitely the situation where you should immediately contact an attorney. There are situations where a child may be at risk of imminent harm, that the child will be removed before a court proceeding. And I will state that one of the critical aspects when that happens, and then contact an attorney, because the case will come into court, has to come into court within 2 days, is there's often a lot that can be done to help yourself in the context of that when you get into court, particularly if there's evidence to refute what the division has said in the context of removing your child. So what's the classic example? One of the classic examples is when the division removes a child purportedly because the child was unsupervised and there's no other adult to care for the child. So under those circumstances, if the division gets a call and they arrive there with police sometimes, they and a caseworker and what they call a SPRU worker, which is a special response unit within the division that goes out sometimes in the evenings and on weekends. and they remove this child. Well, the fact of the matter is that it may just be a misunderstanding. There may have been someone who stepped away for a minute or did something in such a fashion that, the child should not have been removed. And if that evidence is presented in court and the court, makes a finding that, okay, I understand, division, what you did, but the removal wasn't necessarily proper, and they will close the case and order that the child be placed back with the parent. So it's very important under those set of circumstances that you immediately contact an attorney that can begin to prepare a defense for you.
Again, we may sound like a broken record, but so important for those watching this who may have the division in their lives. Contact an attorney. As Marquis said, this can be not only complex, and you need those eagle eyes looking at what's ever filed against you, but time is of the essence. All right, Marquis, this comes up, I feel like, kind of frequently in division cases. I have a drug problem and I live in an abusive household. Maybe there's domestic violence going on. Can the division take my children because of either or both living in an abusive household, or because a parent has an addiction issue?
Absolutely, and I think you're right, particularly in the context of where we are today in society. So say with regard to the opioid crisis that is occurring, all across this country. And you have to understand that in the context of that, if you're engaged in such behavior, the basic position of the division is that you're not in a position to safely care for your child. And if there is no one else there and they learn or get a referral of that, they will absolutely remove your child. And this also comes in the context of children who also, the parents, or the mother may in fact be using drugs during the course of her pregnancy. They can remove that child upon birth, depending on whether or not that child has actually suffered harm from that mother's substance use. And even to the extent that I know most people don't think about it this way, but if you're engaged in certain drug use and et cetera, you could be creating an unsafe environment in your home such that a judge may find that it rises to such a level because of potential police raids or the type of climate that you have when you have drug dealing and things of that nature that are going on, that in the best interest of that child, the child is in an unsafe environment and that child can be removed. The same thing can happen in the context of domestic violence cases, particularly the more serious domestic violence cases where the abuse is going on in the vicinity of the child, or while the child is there, or when the child is actually caught up in the abuse that is occurring between the two adults in the household. All of those present as an unsafe environment for that child that might provide a basis for that child to be removed.
Marquis, if the division does take the step to remove the child, mom perhaps is hopefully going into, a rehab facility, and they need to find somebody, with whom to place the child. Do they look first to other family members before foster care?
They have to.
Okay.
It is a requirement that the division consider what they term it as relative placement. And that's another point, that if you are in one of these situations, you should immediately give the division potential names of relatives that they can investigate as to whether or not they can safely place the child in that relative's care. And understand something too, that under certain circumstances, that may not be a relative that's within your state. It can be an out-of-state relative. And that's why it's very important for you to get that information to the division, caseworker, whomever, as quick as possible, so they can conduct certain checks to make sure that they're placing that child in a safe environment. But they are required to look at relative placements as the first priority.
Great. I sometimes spank my child. Corporal punishment. I know a lot of debate out there about whether you should use corporal punishment at all with a child, but as far as the division is concerned, is spanking your child considered abuse?
It depends on how far it goes. The law, the case law at least supports the notion that it's only excessive corporal punishment that is considered in the context of abuse. How do they define that? Well, surely almost any time that you're going to leave, bruises, marks, things of that nature on your child, is probably going to be seen as excessive corporal punishment. But it's a very touchy subject, and often that line is not so clear. There are a lot of judges who, may support the notion of any spanking almost as excessive corporal punishment, although technically that's not how it's defined by the law. But I think an important point to be made here is and especially if you have an attorney, there's sometimes you need to be very clear under which the circumstances that something occurs, because that can make the difference in how it's seen as whether excessive corporal punishment or something under the circumstances that did not quite rise to that level.
Well, what a wealth of information Marquis provided to us today, and we really, really appreciate it, and thank him again so much for joining us for this little bit of time. Obviously, again, we're lucky to have Marquis here as one of our attorneys, so if you have further questions or you need to speak to somebody who has a high level of expertise in this area, please feel free to reach out to us. Don't forget to subscribe to our Facebook events tab right here on Facebook to be notified about upcoming live webinars so you know what's coming up and when. Here is our contact information. Again, if you'd like to come in and meet with Marquis or one of our other experienced divorce and family law attorneys about this issue or any other issue you may be having, you see our toll-free number is there, 888-888-0919. You can visit us at weinbergerlawgroup.com. There we have a bunch of information regarding not only DCP&P but other family law issues